The following podcast may be disturbing to those who support hatred, terrorism, anti-Semitism, and discrimination. Viewer discretion is advised.
Welcome to another episode of How We Fought Against, where we tell the untold stories of the fight against anti-Semitism, BDS, and terror. I'm Russell Shalev, and with us today is Rabbi Dr. Mark Goldfeder, who's the director of the National Jewish Advocacy Center and an international lawyer. Mark, it's nice to have you here.
Very nice to be here. Thank you for having me.
So you recently wrote an article which was published in the Satan Law Review entitled "Defining Antisemitism." So can you just walk us through your article, please?
Sure. I mean, first of all, I want to just thank you and the ILF for all the great work that you guys do across the board. It really makes a big difference. Anti-Semitism, very loosely defined as prejudice against and hatred of the Jewish people, is often called the oldest form of hatred, but it's also the most persistent. And without a good definition of what it means, it's almost impossible to fight it. And there's been a real gap in anti-discrimination law, even when it's illegal in the United States under, for example, Title VI and Title VII. People don't know what that means, which makes that implementation of the law arbitrary. And what you really need is an objective standard. And my article explains why IHRA is the correct objective standard for that kind of an approach.
So maybe the first question should be, in the past several months, we've seen two definitions that have come out that are meant to either be alternatives, either to edit or to completely replace the IHRA definition. So can you please explain why aren't those definitions useful, and why is IHRA the preferable definition?
Because we hear all kinds of criticisms about IHRA, especially from these new definitions, and most of them are very unfounded. And so you might want to ask yourself, why did IHRA become so accepted in the first place? And the answer is because IHRA is a really good definition, and I'll explain why. I like to start with an observation from the late Chief Rabbi Lord Jonathan Sacks Zatzal, who believed that in terms of its focus, anti-Semitism often looks at Jews as a collective. The idea being that while individual Jews might be tolerable, Jews as a separate collective entity should not be allowed to exist with the same rights as other groups. And that's why the majority of anti-Semitism in any given era tends to focus on the primary form of collective Jewish identity at that point in history. Throughout the Middle Ages, Jews are the most part of a religious community, and they're hated for their religion, even if the particular Jews being oppressed weren't, particularly religious. In the 19th and 20th centuries, Jews become secularized, and the primary unifying collective identity of Jews is their ethnicity. And so the hatred mutates to focus on race, even when it's only trace amounts of Jewish blood in the Nazi ideology. Today, when the primary collective embodiment of Jewish people on the world stage is the people of Israel in their nation state, Jews around the world are hated and held accountable for their state, even if they're not Israeli. So the practical problem of defining anti-Semitism is that, as Rabbi Sacks said, it's a mutating virus. Jews are criticized for whatever a society or a particular part of society where they live hates at that particular moment. The right will call them radicals. The left says they're fundamentalist. They're too liberal, too conservative, too rich, a drain on society, too strong, too weak, too influential, too parasitical. A definition of anti-Semitism that can encompass all of these possibilities and more needs to be able to cut through what I call the timely rationales for that timeless hatred, because if you don't, anti-Semites will just find another rationale and use that one, and then another rationale, and then another. If you want to actually protect people practically, what you need is a definition that focuses not on the reasons why people hate, but rather on the actions taken by those expressing or harboring the hatred. It's called a praxeological or conduct-based definition, if you will. The definition that best serves this goal is the IHRA definition, and it's precisely because the examples that it gives focus on the manifestations of anti-Semitism, meaning what anti-Semites do as opposed to why they do it. And that is what makes IHRA such a good definition. Yes, its strength comes from the consensus of tens of thousands of people across every spectrum agreeing that this definition best represents their shared lived experience. But the way IHRA does that, the reason why people feel that way is because even though anti-Semites around the world give different reasons for their feelings, those feelings tend to manifest themselves in similar repetitive patterns. Now, the pushback on IHRA, the main pushback from both of those groups, comes from the fact that among the list of potentially anti-Semitic behavior provided, the definition includes useful examples of discriminatory anti-Israel acts that can sometimes cross the line into anti-Semitism. And there's nothing wrong with that, and it well should.
Well, there's a critique against IHRA, against the IHRA definition, that it somehow sets the fight against anti-Semitism separate from the wider struggle against racism, and it treats anti-Semitism as somehow different than other forms of racism. It's in fact privileging Jews. What do you think about that claim?
I honestly think it's ridiculous. There's nothing involved in IHRA that is in any way about Jewish exceptionalism. It's about ensuring equality. And there's absolutely nothing wrong with Jewish people standing up and saying, we need to be treated equally. You know, there's nothing wrong. People talk about IHRA as limiting speech. IHRA doesn't do anything. IHRA is a definition. Okay, we're talking about using it in policy context. We can talk to that in a second. But IHRA itself, all it does is identify what kinds of speech are problematic. No one thinks there's any First Amendment or chilled speech concerns when you say, hey, that racist speech is racist, or that sexist speech is sexist, or that homophobic speech is homophobic. There's nothing wrong with Jewish people saying anti-Semitic speech is anti-Semitic. Hate speech is protected. As a First Amendment attorney, I fully respect that. It's an important cornerstone of our democracy that free speech should be tolerated even when you don't like it. But there's nothing wrong with calling what it is hateful.
It seems that anti-Semites often want the freedom to say anti-Semitic things without being called out on being anti-Semitic.
Mm-hmm. Exactly.
So anyways, can you show us practically how would the IHRA definition be used in law to fight against anti-Semitism?
Sure. I mean, there's a couple of ways that IHRA can be used. Let me start with the ways that it can be used not in law, because those should be the least controversial, right? Use of IHRA should be, it's a definitional tool. So it should be used to educate people, whether it's a university community or a broader community. Well, let's take the example of the university, because that's where a lot of the debates are happening today. So students, faculty, administrators, staff, security personnel, mental health care workers, they all get training on all of their diversity and inclusion trainings in their orientation programs, their non-discrimination harassment policies, and their student and faculty conduct codes. And that's where you get to some of the legal questions. We'll come back to that in a second. But one really important thing for schools to do is that in the event of an anti-Semitic incident, right, that does involve, for example, protected speech, so IHRA is not going to do anything to it, but the university should still publicly respond with their own counter speech, utilizing the IHRA definition in a non-regulatory manner to just help educate the community about why that offensive speech is anti-Semitic and therefore repugnant to the university's values of diversity, respect, tolerance, inclusion, etc. The same way that it calls out racist speech or sexist speech or homophobic speech. In terms of in the sort of legal implications that we talked about a second ago and using it in policies, IHRA should be used carefully. It should be used to evaluate conduct that has demonstrably and harmfully impacted Jewish community members, to contextually evaluate potentially anti-Semitic motivation. And let me break that down for you, because this is where a lot of misunderstanding comes up, particularly as it relates to the executive order that from a couple of years ago under President Trump. So let me take a step back for a second. Under Title VI of the Federal Civil Rights Act, recipients of federal funding, like most universities, are required to ensure that their programs and activities are free of harassment, intimidation, and discrimination on the basis of race, color, and national origin. Now, thanks in large part to the work of Ken Marcus, in 2004, the Department of Education clarified that Title VI includes anti-Semitism to the extent that it implicates ethnic or ancestral bias, and it very often does. It's rare that you find anti-Semitism because somebody doesn't like the fact that you light Shabbat candles, right? Usually it's about the ethnic or the ancestral origin. Okay. It's important to remember that even under Title VI, not all forms of harassing behavior are illegal. It's only illegal and it can only be regulated if it is based on an illegal discriminatory intent. The problem for the Office of Civil Rights was that without a definition of anti-Semitism to use as a reference, there's an unanswered question there of how to determine what is and isn't illegal anti-Semitic intent. So in practice, what this meant was that Jewish students were always vulnerable to anti-Semitic attacks and then obfuscation when people deny the motivation, say, it wasn't based on anti-Semitism, was based on anti-Zionism. So what OCR, the Office of Civil Rights, needed was, as the Supreme Court would say, a definition of behavior that was objectively anti-Semitic. And that's why on December 11th, 2019, the government announced an executive order saying that when evaluating these claims, the department should consider the IHRA definition of anti-Semitism. To be clear, this doesn't create any new law. What IHRA does is it plugs a hole in existing anti-discrimination law and explains how the government should interpret it. And despite what critics would have you believe, this is not at all uncommon. For example, recently on his very first day in office, President Biden issued a very similar executive order clarifying that gender identity and sexual orientation are to be treated as sex-based classes under Title VII, right? Again, he wasn't creating new laws. He was just clarifying how the federal government understands and applies the definitions in existing anti-discrimination law. All IHRA does is plug a similar hole. And that's all the executive order did, the exact same thing. It doesn't limit speech because it only deals with conduct. And rather than muddying the water, it actually clarifies, right? It ensures that the law will not be applied arbitrarily. So when should you use IHRA in a policy, in a sort of a legally binding type way? It only comes up really in the context of a Title VI discrimination claim. It's only after a person has been credibly accused of engaging in discriminatory acts, not speech, towards Jewish people that are so, and I'm quoting now from the Supreme Court, severe and pervasive that they limit the ability of the victim to participate in or benefit from an educational opportunity. Then and only then does the department use this definition as contextual, rebuttable evidence of a discriminatory motive. It doesn't even say in their definition that it's always anti-Semitic. It says it could be anti-Semitic. And to the extent that any examples might be useful as evidence of discriminatory intent, and with the specific caveat that whether a particular act constitutes discrimination prohibited by Title VI is obviously going to require a detailed analysis of the allegations because context matters. So taken in that light, I mean, there should really be no serious concern of chilled speech. If you're criticizing Israel even harshly, this has nothing to do with you. If you're actually engaging in discriminatory conduct against Jewish people to the extent that they are unable to participate in educational opportunities, and your motive seems to be based on their race or national origin, maybe you should stop and think twice about the impression that you're giving, and there should be nothing controversial about that. You know, unfortunately, it's a necessary corrective for the reality that on campuses across the country, students engage in horrific anti-Semitic behavior under the guise of anti-Zionism. Not all anti-Zionism, I believe, is anti-Semitism, but much of it is. And the use of IHRA in these policies only touches the kinds of egregious behavior that the First Amendment does not protect.
Okay. You know, there's an argument that that boycotts in general, boycotts, exclusion of individuals involved in policies that one disagrees with, you know, is a well-used tool of civil pressure. So, right, in the same way that, right, South Africa was boycotted, somebody who's opposed to Israel's policies might also to choose to boycott individuals of Israeli nationality. Would this be protected? Would this be a violation of Title VI?
No, it's a great question. And let me clarify this because you're hitting on a lot of good points. The BDS movement is demonstrably anti-Semitic. BDS itself, the action of boycotting Israel, is not necessarily anti-Semitic. The movement and the action are different. But, and this is a really important distinction, and it's probably too legalese to get into right now, but I'm happy to direct you to a longer article I've written called Stop Defending Discrimination. Anti-BDS laws are fully constitutional. It really breaks this down. You see, what the other side has done is conflate the kind of boycotts that are protected under the First Amendment with the kind of boycotts that are not protected under the First Amendment. There's a difference between a primary boycott, where you're boycotting something that you disagree with, which is the kind of things that happen in the Supreme Court cases mostly that talk about boycotts, and secondary and tertiary boycotts, where you're not boycotting the person, you're boycotting someone who you think does too much business with someone that you don't like. You're involving a neutral third party in your disagreement, and that isn't protected the same way under the First Amendment. And what people like to do is just throw around the word boycott without explaining. BDS as a primary boycott is probably protected in a lot of contexts. BDS as a secondary and tertiary boycott, especially when it infringes on United States announced policies and individual states' policies on business practices, is not protected in the same way.
I mean, the way I see it, right, without getting into the legal distinction, but boycotts themselves are just a neutral tool. They're neither good nor bad, right? And in America, because of American history, there's a certain romantic view of boycotts. But there are some boycotts that are good, as in those in the civil rights movement, and there are boycotts that are bad, right? The Nazis began by boycotting Jewish businesses. So it's all a matter of what the goal, the purpose of behind the boycott movement.
Sure. And again, I know oftentimes, unfortunately, the quote unquote nonviolent veil of the BDS movement, and again, I'm distinguishing between boycotts and the BDS movement, which is demonstrably anti-Semitic in its goals, in its policies, in its original manifesto. Oftentimes it breaks through that quote unquote anti-Zionistic veil into raw anti-Semitism. And so you get a real sense of motivation. But for a person who truly feels that they want to boycott the state of Israel to complain, that's 100% protected, and I respect their right to do that. But how often do you see that? If you truly think that Orange Cellcom has the ability to change Israeli policy, you're wrong. And if you weren't just wrong on a factual basis, you're wrong on a legal basis, and there are good reasons why you're not allowed to do that.
So can you give us just a very practical case, right, in which current anti-discrimination law without IHRA, right, is lacking?
Sure. I'll give you a type of case, which is unfortunately what we see all the time. You'll see something happen on a campus that, in my opinion, and in IHRA's opinion, I will say, is clearly anti-Semitic. And immediately, the first response is it's not anti-Semitic. And in fact, we even have a couple of Jews who are in the group too, so it couldn't be anti-Semitic, which is not an excuse. And again, in other contexts, we recognize the phrase, well, my best friends isn't an excuse for discrimination. It's almost a laughable assumption, but it works here for some reason. It was just anti-Israel.
It's right? It's as if somebody's directed at Israel, it cannot be anti-Semitic.
Exactly. The point of the definitions in IHRA is explicitly not because all anti-Israel, but because some is, and the other side says that none is, and it's just not true. When you're using the same tropes of classic anti-Semitism on the Jewish state, the Jew amongst the states, and applying it especially to people who are not the Jewish state, then it clearly is anti-Semitism. But what you see is that, and so you come to the university board and you say, hey, listen, under your conduct code, existing discriminatory code, this is a violation, and it's a violation of Title VI because there's clearly illegal discriminatory intent. And they'll say, there's no definition of anti-Semitism, so who knows? Who knows whether it is or it isn't? And if you don't have an objective standard, then you can never answer that question. So IHRA plugs that hole in existing anti-discrimination law.
Right. I remember you mentioned in your article a case, I believe, in Germany where a synagogue was attacked by anti-Zionists protesting Israel's policies.
They firebombed a shul that had already been destroyed in Kristallnacht, only recently been rebuilt. And when they got to court, you can guess what their explanation was. It wasn't They weren't firebombing this Jewish house of prayer full of German Jews because of anti-Semitism. It was their way of being anti-Israel. And because there was no good definition of anti-Semitism, the judge accepted that and they were exempted from criminal time. Not too long after, Germany adopted IHRA. And the reason is clear. If you don't draw certain lines in the sand and police those lines, then people will exploit them.
So just circling back to earlier in the discussion, right? So what does criticism of Israel look like versus anti-Semitism?
That's a good question. So let me give you a concrete example to help you differentiate, right? Mahmoud Abbas, president of the Palestinian Authority, arguably the world's leading advocate for Palestinian rights, someone who vehemently criticizes Israel. To agree with his political views is not inherently anti-Semitic. To agree with his public statements denying the Holocaust and blaming it on Jewish victims is inherently anti-Semitic. When is criticism of Israel anti-Semitic? Generally, sometimes the answer is clear. When you use classic anti-Semitic tropes to talk about the collective Jew among the nations, as Rabbi Sachs would say, right, as a proxy for how anti-Semites historically talk about Jewish individuals. So that means, using certain stereotypes, accusations of Jewish conspiracies, blood libels, portraying Jews as satanic, demonic, evil, accusing them of dual loyalty, et cetera, et cetera. When that happens, the symbols and the signals that people are using for their anti-Zionism often belie their true intent. Again, I'm not saying that speech should be criminalized or contained. It should just be labeled correctly as anti-Semitic. Sometimes it's not as obvious to a casual observer, which again is why there needs to be a definition to assess context and motivation. That's also why anti-Semites don't like the IHRA definition, because it takes away their freedom to push past the line. So in practice, right, denying history to claim that Jews are not indigenous to Israel, or denying only the Jewish people their right to self-determination, which again, if you want to talk about international law, it's consecrated in both the International Covenant on Civil and Political Rights and the International Covenant on Economic, Social, and Cultural Rights, or at the same time calling for the elimination of the world's only Jewish state or ethnic cleansing of the region, right, from the river to the sea, or genocidal extermination of the millions of Jewish people who actually live there. Those are all examples of things that are likely to be anti-Semitic depending on the circumstances. And I say depending on the circumstances because even IHRA says not always. So for example, if you think that Israel does not have the right to self-determination, or you think that no country has the right to self-determination, you're not an anti-Semite. It's only when you single out Israel and say everyone else does, but for some reason, Israel, the Jewish state, should be different. So when criticism of Israel is done in a discriminatory manner, meaning when it's singled out for disparate and disparaging treatment, not for what it has done, but because of what it is, a Jewish state, that type of anti-Semitism should not be taken lightly, and for two reasons. Number one, it's ethically objectionable, but number two, it's very, very dangerous because, again, we talked about this. Sometimes it breaks through the non-violent veil, and it actually leads to, whether it's individual students or student groups singled out and discriminated against because of their stated or assumed support of Zionism, and it can often lead to violence.
In one of the alternative definitions of anti-Semitism, instead of referring to the calling for the destruction of the state of Israel, they use a euphemism of alternate constitutional arrangements between the river and the sea. So somebody just thinks that the state of Israel should not exist, but that's not anti-Semitism. We shouldn't see that as anti-Semitism.
That's an interesting one. That particular line, I think, is a gray area in the following sense. It doesn't do anything IHRA doesn't do. It's not worth having it, and all it does is undermine the consensus of IHRA. But even leaving that alone, it does allow for anti-Semitism in the following sense. Exactly like you said. If you think that alternate agreement should be a two-state solution, that's not anti-Semitic. But if you think the alternate arrangement should be no state of Israel and ethnically cleansed Palestine, then yeah, that is anti-Semitism, even if you frame it in a polite society way of it's just an alternative form. It's not. There are millions of Jews that live there, and they wouldn't be there anymore. Where would they be?
Right. Well, Well, thank you very much for this enlightening discussion. To our viewers, please like our podcast. Leave us a good review if you liked what you heard. And Mark, where can our listeners read more about your activities and about your work?
Sure, you can check out the JewishAdvocacyCenter.org. We're on Facebook, Instagram, and hopefully we'll be doing more with groups like yours in the future.
All right, thank you very much.
Thank you very much for having me.